welcome to Legally Speaking with me, Tarun Nangia. Now we embark on the part 2 of our discussion on whether a person can be kept in jail behind bars post the filing of charge sheet. And in the part 1 of this discussion, you heard a very interesting intervention, which A was the discretion of the judge or the hunch of the bench, as Mr. Pahwa said, but also there was this point on the quantum of the scam. That if the quantum is more, it is almost certain that a person will be put in jail without being held guilty. The trial has not happened, but it is certain that the court may put him behind bars. So I remembered a line that I read in a book authored by Lord Justice Tom Bingham. He was the Chief Justice of England and Wales. He said, where law ends, tyranny begins. So is it tantamount to tyranny that you keep an individual who's not yet been held guilty behind bars? In that period, what happens to his business? How will he pay the loans? How will salaries be paid? And in India, how companies are promoter driven? We all know companies in India are highly promoter driven. If the promoter is behind bars, you're not even putting the business in tyranny. You're also putting all the employees' future in under a cloud, under a question, because the company may go into a big problem. It may not be run well. How will the loans be paid back? There is a threat of bank NPS. So are we seeing it in a very simplistic way, just putting a man in jail? Aren't we thinking of the effects on the economy and what kind of threat perception will it create if a businessman is just thrown behind bars? We'll discuss all of this and we'll continue our discussion from part 1. Abhimanyu, if you can share with us, Mr. Senior Advocate P.K. Dubey ended the last show by talking about the reasons that the court records for keeping accused in jail. If you can share with me this issue of quantum, how a quantum can be a determinant or can it be a cogent reason for keeping somebody in jail when he's not been held guilty? Can you address this and move ahead?
Yes, I think in matters, when people come and throw big numbers, then of course that creates a huge amount of prejudice. And one person feels, you may feel 100 crores makes the gravity of the offense much more. Someone else might feel that no, 1,000 crores makes it much more. And I think that the perspective of looking at it from a number point of game is completely wrong, because for me, 100 crores might be a big thing. For someone else who has a turnover of 10,000 crores, for him, 1,000 crores is 100 crore for a person, So it depends from businesses to business, and also depends on the net worth of the individual that you're dealing with. But in economic offenses, we are getting too swayed by this system of throwing numbers and by saying, this 1,000 crores, that 1,000 crores. And at the end of the day, Tarun, I have seen in many cases that by the time the charge sheet is filed, that number really trickles down to a much lesser number. So throwing that number, when a person is applying for bail and creating a prejudice, this is something that I think court should now put a full stop to and start seeing through that. And we should not decide people's bails depending on how much money is involved in it. What we should see, I think, is that whether this person is a repeat offender or not. Is this person who's done a multiple number of scams? A person who has cheated 5 people of 10 crores each probably doesn't deserve bail, because we are worried that he'll get out of jail and cheat the 6th person. While a person who may have, his company may have collapsed and there may be 1,000 crore loss to a bank and who may be hounded by investigating agencies, but he did build up a business, right, worth 10,000 crores to lose 1,000 crores. And maybe tomorrow in trial, he's able to prove that he was innocent and the money was actually used for business purposes and it was a business loss. And as Mr. Dubey said, it is a commercial dispute and not a criminal liability. So really, one should not look at it from that perspective at all, because a person who may have, been involved in a much lesser scam might be more dangerous to the society than someone who's getting hauled up for the first time for a big loss that his company's incurred. So I think that's a completely wrong way to look at it. But I think a great point that came out on the last show was, and which I think there was a mixed opinion among the panelists, was that the last few judgments that we've seen from the Supreme Court, whether that has created more clarity that one should get bail once charge sheet is filed and if he's not been arrested, or has that added to the confusion? And Tarun, I think my take on this is, and it's an important take, is that I think that we have moved. I think Siddharth versus UP was an absolutely great judgment. Personally, it helped me get bail in many of the other matters where my clients who were not arrested during charge sheet, and these clients were some were builders. One was a client that Mr. Mir was handling at the trial court, and I had to go to Supreme Court for him because from the Ghaziabad trial court, that person did not get bail when that person was never arrested by the CBI. CBI came to a decision not to arrest that person in an economic offense. But the one had to go all the way to Supreme Court to get an anticipatory bail. But all that was achieved because of the judgment in Siddharth versus UP. So Siddharth versus UP came in very refreshingly, reaffirming the position of law and helping a lot of people. But then came the Antil judgment. And the Antil judgment came like this big rock that fell on us. And then it had that sentence on the PMLA bit also, which created a lot of confusion. Thankfully, Antil got clarified, and that has come a long way in helping us. But as Mr. Pawar rightly said, please let's move on and not categorize offenses, whether it is a murder or whether it is an economic offense. If the investigating officers made a decision not to arrest you, then after that, what is the point of categorizing those offenses and saying in an economic offense, you should get, or then you really have to go on the general basic bail jurisprudence. So although Siddharth versus UP was this great judgment, I think Antil has tempered the severity of that judgment to some extent. But all said and done, I think today we are in a better place with Siddharth versus UP than we were without Siddharth versus UP.
Point well taken. I'll take this to Advocate Nitesh Rana. Now, we spoke from the side of the business community that the businesses may fail if the promoter is put in jail. So any possibility of even recovering money fails because once a promoter in jail, we know that everything in a sense in companies goes into trouble or a tailspin, as we may say. But on the other end, if I may ask that sometimes there is a talk that there is a flight risk that a person may run away or such things are cited. How does that play into the minds of the court? And second, if you could address this question, whether the big numbers that are thrown out, scam of 10,000 crores, 15,000 crores, or as Abhimanyu said later, it is found that it is a fraction of that amount. A 10,000 crore scam may turn out to be a 50 crore offense. Can you share with us how these two things play out? The big number that is thrown initially and the issue of flight risk that is raised time and again in the courts, that the person may flee, he may tamper with the evidence. So it's better to keep him in jail. Can you share that?
I will take your question, first question first, Tarun. As far as the flight risk is concerned, we have seen for last couple of years, many people have committed offense in the country and they left the country. We are not able to bring them back to our country and face the trial, face the judicial system over there. So that is kind of one apprehension. Look, people are leaving the country. They are going to another country, remote areas, take citizenship, they pay. So that is one part of it, really a matter of concern for all of us, whether lawyers from that side or this side. It's a general citizen, every citizen's concern. Many people fled away from the country and we are not able to bring them back. So this is definitely one of the major issue, and all the courts, judges keeps in mind if bail is granted, whether there is a likelihood that the faith, that the trust court has confided in an accused is going to be abused. If that is so, definitely judges takes precautions and bails are not granted to those accused. However, see, I totally agree with the rest of the panelists. I concur with Abhimanyu Bhandari also. In a case where the accused were not arrested during investigation, that means custodial interrogation of those accused are not required. Their name is in the charge sheet. So those people, those accused, bail should be granted, and on the all those precautions, conditions may be put on them. And apart from that, your second question was that whether the big numbers, definitely this is a matter of concern. See what happens, what is happening in a country right now. When one matter is taken up by the agency to investigate, whether it's a CBI or XYG, it's an economic offense, Delhi police or anything, initially they register, let's take it, one FIR. Once they are investigating the matter, slowly, chapters, new level comes, new chapter, new steps comes and all, and they find this is becoming larger. So, when and the bail applications or bail are come at the initial stage of it. So, agency has to give, look, this number is increasing day by day. When it is coming to the final conclusion, well, let's take it final, a charge sheet comes before the court, that number may vary. They can go lesser, that can go higher. But when you're investigating the matter, you see, I know a couple of matters where the investigation started with few crores, 1,000 or 2,000 crore. Eventually, we found that this matter has gone up to 17, 18,000 crore. So this is not something, any agency just throw the numbers. It is about at the initial stage, nascent stage, the agency are not able to actually figure out what exact is the figure. So that is why at least one approximate figures are given to the court.
Point well taken, Mr. Nitesh Rana.
I'll answer one more question. How these numbers are affecting the bail process? Definitely, Tarun. See, the economic offenses parameters have been set by the Supreme Court differently. Not now. People, the lawyer says, look, PMLA or XYG matters. No, not going to that. 1984, Supreme Court has set the parameter for economic offenses, said these offenses are very serious, rather serious than murder cases. So we see economic offenses are very different. These economic shenanigans have been kept as a class apart. So, right now we are discussing the general principle of law, not on the economic offenses especially. Let's get into the UAPA. See, UAPA, you won't find the money involved. But the offenses of UAPA, whether it is a terrorism or terror funding or anything, so all these offenses are very, very serious nature. It's a felony of very, heinous crimes are there. So these factors are there in the mind. I believe the court keeps in mind while exercising the jurisdiction of it.
Point well taken. But today, Mr. Nitesh Rana, we are limiting to financial crimes and businessmen. Of course, I understand when you say it's terrorism, it's a completely different ballgame. So obviously, those liberties won't apply in that sense. There is obviously an apprehension that, they shouldn't be let out. But that's for another day. I'm going to Advocate Tanveer Ahmed Mir at this point. And if you could share with us that A, the issue of flight risk, second, this issue of big numbers being thrown, and thirdly, do you think Supreme Court should come down heavily on other courts in the country for violating its guidelines on bail time and again? Because imagine the plight of a lawyer who flies down from Delhi to represent his client in Ranchi or Bilaspur, and when he is arguing before the court, he feels that he has made a reasoned argument and it almost falls on deaf ears. The Honorable Court says, no, I'm not convinced. And the lawyer thinks that, okay, I'll now have to go to the Supreme Court to get a bail for my client because he deserves it. Do you think that the Supreme Court could, in a sense, issue some guidelines so that there is clarity on this issue? Because the point is, you will say there are judgments, but if the courts are not following it, are the judgments having any effect? Could you share that with us?
So, Tarun, you could not have put the point better. I think it's directly on the head of the nail. So let me start with your third point, is whether the Supreme Court should, take a very strict note of it. And I don't think that the Supreme Court has not done these kinds of things earlier. Now, for example, one of the reasons why a 3-judges bench of the Supreme Court in Arnesh Kumar versus State of Bihar, enunciated the bail jurisprudence to a very good scrutiny again is because in offenses even up to 7 years, whether they are economic or otherwise, there was a havoc in the country. Now, they said, that the practice of investigating agencies in arresting first and investigating later is most despicable. And these are the words used in the judgment. Now, where the Supreme Court time and again have been giving certain guidelines, they are finally, and cumulatively based on one fundamental and cardinal principle, that bail is based on liberal jurisprudence. Why is that? That is because a person is supposed to be condemned into a incarceration, into a correctional facility or a jail only upon conviction, not prior to that. So any act of judicial dispensation which tends to deny liberty to a person who has not been even arrested during the course of investigation is in direct violation of the fundamental rights under Article 21. And Tarun, why is that? Because under Article 21, we as a nation, as a democracy, as a secular country, on the principle of rule of law, we subscribe to a philosophy of presumption of innocence till found guilty. Now, it is there that your constitutional right gets affected. So Supreme Court has to see that where their judgments, be it Gudikanti Narsimulu, be it Justice Krishna Iyer's other judgments, be it judgments passed later, be it Arnesh Kumar. And in Arnesh Kumar's judgment, they have said that if a notice under 41A is not given, or if the guidelines are not followed, then the investigating authorities will be taken to task. In similar manner, they can do it. That is one part of it. Second part of it is that why should a person go into custody after filing of the charge sheet if he has not been arrested? Now, let me tell you, the purpose of curtailing the liberty of a person fundamentally is to put him to the sword of custodial interrogation, which means that, sir, I as a police officer, I as a prosecutor, I cannot effectively investigate unless his custody is not given to me. That is why the law says under 167 of CRPC that the moment a person is arrested, 15 days of custody can be given to a police officer so that he can perform his obligation. Now, where investigating officer himself says, I don't need his custody for my unfettered investigation, for my smooth investigation, and I am doing absolutely fine. I have a beautiful charge sheet. I have all the evidences on the docket, and I will secure this conviction. Then for the judge to go and play with discretion again, and I'll end my submission or my comment, as you said, and you referred to Lord Burghley. There is a very famous jurist from England called Lord Camden. And he said that discretion, when applied to judges, is like the law of tyrants. It comes from unknown. It differs from men to men, person to person. At best, it is casual and depends upon temper and passion. Now, that's exactly what happens. Now, let me give you one last example. I did 2G spectrum trial. Perhaps 2G spectrum was 1,70,000 crores. Finally, acquittal, which I think can't be even reversed. So why did you go into custody?
I'll go to Vikas Pava at this point, Senior Advocate Vikas Pava, and this question is equally to Senior Advocate Vikas Pava, thereafter Senior Advocate Pramod Dubey. But before that, because of what Advocate Tanveer Ahmed Mir said, I like to say that Lord Oliver's son appeared before him and never a question was raised. So discretion is something that works both ways. When a person's integrity, his character is above suspicion, then even the son's offspring can appear before a judge and there'll be no questions asked. Sure. But that is for another day. Senior Advocate Vikas Pava, some senior advocate, somebody of the stature of you, flies down from Delhi to a state capital, to a high court. You tell the honorable court that the Supreme Court has issued such guidelines, give my client bail. He's a businessman. He's not a flight risk. He's got a lot of investments in the country. You also say that the Supreme Court will give him bail in case you don't give, because the Supreme Court is saying charge sheet has been filed. You till the trial takes place, you don't keep him in jail. When the court does not appreciate even you citing the Supreme Court's judgment, what do you make out of it? What do you feel at that time? That the high courts are in a sense not ready to follow the Supreme Court orders and the guidelines? Your intervention on that.
Well, Tarun, it happens quite often. It's not that, bails are granted on a drop of a hat nowadays. There was a time when even in a trap case under Prevention of Corruption Act, once the trap is concluded, against a public servant, and his hand wash is taken, the money is recovered, and the document is prepared, he was allowed to go back home. You'll be surprised. I'm talking about late 80s, early 90s. There were no arrests.
Because even in 2000s, this did not happen.
Yes.
Even
So
in 2000s,
today, unfortunately, every police officer feels that he has to arrest the individual, particularly when, as you rightly said, when the quantum mentioned. Now, you'll be surprised to see that quantum varies from stage to stage. When an accused is arrested, the quantum is much more. Like in GST cases, if we see whenever an accused is brought to a court and a remand application is filed, the amount may be mentioned, say, around 1,000 crores. And the pressure on the court is the quantum, 1,000 crore. And when he's not allowed to be released on bail, and within 60 days the complaint is filed, the amount is reduced to 10 crores. And immediately thereafter, he is released on bail. Problem is that this gravity in economic offense is now reduced to the figure, as Abhimanyu has rightly said. So the court should not go into the figures at all. There are no precedents in criminal law. You must understand this also. There may be precedents in civil law, but in criminal law, there are no precedents on facts. There are precedents on law. So we can't tell the High Court or to a lower court that since the Supreme Court says that bail should be granted in on all the offenses, which are less than 7 years, so please grant. We can only cite. But at the end of the day, the judge has to satisfy himself. And judge feels that if he grants the bail to the accused at an early stage, then probably the investigation will be hampered. So therefore, the bail applications are deferred. Very often, the courts have started saying, wait for 60 days. Wait for 90 days for the charge sheet to be filed. The circumstances have changed. So Supreme Court law is one thing. Following that law is something else. We can cite, as a lawyer, we cite. Mr. Rana and I, have an occasion to appear together in many cases. Recently, we went to, Ranchi, and there we cited these 3 judgments of justice called to the court. And he was not even aware of these judgments. So we read all the 3 judgments to him. We explained it to him that in this case, the accused has not even been arrested when charge sheet is filed. He's not even arrested by the investigating officer because of investigation. He is arrested because non-bailable warrants have been issued because he was not present. So we can do our job, we can do our duty, we can inform the court, but at the end of the day, it's the court who has to, satisfy itself.
point well taken.
One last thing. So therefore, as a lawyer, you are right. When you ask me a question, what do I feel? I feel extremely bad when I see that the Supreme Court judgments are not being followed. That is why today, in every case where there is a high quantum, the bails are granted by Supreme Court, not by the lower court judges, not even the High Court.
This is indeed very unfair.
Yes, it's very, very unfair. Why should Supreme Court be burdened with bail applications? And Supreme Court judges not once, many times have said, why are we deciding the bail applications? The anticipatory bail has to go to Supreme Court now. That is why we require a complete reworking of the system on bail. The jurisprudence has to be
well taken. Now I'll take the same question put to you on quantum of the crime to Senior Advocate Pramod Dubey. Mr. Dubey, you appear in the Supreme Court of India. You go and appear in the High Courts. When bail is treated differently or looked upon very differently by Supreme Court and High Court, and when you are giving citation of Supreme Court orders, judgments, and that is being not appreciated by High Court, what does a lawyer like you do? When have you faced these situations?
Tarun, recently one of the panelists mentioned that the big number does matter. I would say the big number does not matter in deciding the bail application. Why so? Because in criminal jurisprudence, especially in the penal code, you have to see the quantum of the punishment, not the quantum of the money. Suppose the offense is 420, the maximum punishment is 7 years. Whether the cheating amount is 10 lakh rupees, 10 rupees, or 10,000 crore rupees. Ultimately, you have to justify if the person proved guilty, then the quantum of the sentence. Where is the question of the appreciating the big numbers and deciding the bail applications on the big numbers? We have entered altogether the different field which is unknown in the bail jurisprudence and the criminal jurisprudence. Everywhere we are appreciating the bail with the big numbers, though there is no concept. Economic offenses, what are economic offenses? The ultimate punishment is 420 and the punishment is 7 years, and which is compoundable. Number one. Number two, Mr. Rana said that there is an example from the film from the justice. I have not come across any case, especially in Delhi, where the accused, after the filing the charge sheet, has fled away from the reach of the court. Because once the accused has not fled from the justice during the investigation till the filing of the charge sheet, on what basis you are opposing the bail by raising the objection that he will flee from the justice? So these are the two counts. Third, Tarun, the only exception, we have 4 provisions of bail in our criminal jurisprudence, CRPC, 436 that meant for the bailable offense, 437 regular bail before the ministerial court, 438 anticipatory bail, and 439 before the session or high court. That is the concurrent jurisdiction. The only exception, Tarun, for the ministerial court is the life sentence or death sentence. Only exception is light of death. Now we have come across the categorization of the offenses. These categorization of the offenses are not mentioned in the CRPC. So this all categorization is against the procedure established by law. This is the A, this is the B, this is the C, this is the D. So this categorization, as rightly pointed out Mr. Pawar, he has created a lot of confusion. But fortunately, the Supreme Court is willing, and the matter is next listed on 8th March. And we are hoping that there would be a review of this order and there would be some clarification. Because the purpose of this clarification was to encourage the bail, not to discourage the bail. But the lower judiciary, High Court and the other court has taken the other way. You know, these are the categorization. You have committed the offense, you are falling in category A, falling in category B. And if you see the special acts, you rarely find in a special act the punishment is death or life in the economic offenses. We are 7 years or fine or both.
Point very well argued and point very well taken. One final comment to Advocate Abhimanyu Bhandari. We've just about a minute and a half left before we end. You're not audible.
I think we've had a great discussion, and I think everybody agrees on one thing, is that we have moved forward now with the decision of Siddharth versus UP, and that's come to a great rescue. And I think that it's now becoming easier to get bail once charge sheet has been filed. Delhi, we don't face that problem as much as we face in other parts of the country. And as I think Mr. Pramod Dubey tells us that, this case is again coming up, this issue is again coming up in Supreme Court soon. We just hope and pray that there's further clarity on it. And further, they make it easier for people accused to get bail if charge sheet has already been filed and they were not taken into custody. I think we need a strong judgment from Supreme Court, strong, clear, coherent guidelines from Supreme Court. And I think that will solve this entire issue. Yes, as on today, businessmen face huge amounts of problem if they have to go and really struggle to get bail in offenses where the investigating officers made a decision not to arrest them. A businessman should not spend time fighting bails. Rather, he should be focusing on the business. And really, if he's been accused of something, then the trial court should do the trial, and that should kind of decide whether he's culpable, guilty, or not guilty. But yes, I think broadly speaking, we now need to really rise to the occasion where we make it very clear that bail is a fundamental right if you have not been arrested during investigation.
Point very well taken. Mr. Pawar, about 10 seconds because we are totally out of time.
Yes.
We can't.
I would like to point out recently, I think in Punjab Haryana High Court, the division bench, while dealing with the GST matter, released the person on bail primarily on the ground that he was the managing director. And there were about 1,000 people working under him. And the Honorable High Court pointed out that by putting him behind bars, we'll be jeopardizing the career of those people. And because he is the person.
Punjab and Haryana High Court.
Yes, in GST matter, primarily on the ground that he is the head of the family in the business. And if he is behind bars, then day-to-day functioning of the business will be hampered. Out here, after these 3 judgments, the principal accused are being denied bail, and rest of the people are being released on bail. Out of 25, 20.
This is a very good point. This is a very good point.
Bail, but main people are not.
But I have.
And I would like to just add, Tarun, the principal person denied bail in Delhi and got the bail in Bombay in same ED matters.
Yes.
In same ED matters, he got the bail in Bombay.
Point very well taken.
Just give me one last point to make, because Pramod will be arguing Satinder Antil again. So now Satinder Antil, what I see is a 2 judges' opinion. Perhaps Pramod needs to go back and inform the Supreme Court that in P. Chidambaram's 3 judges bench, the Supreme Court in unison said regarding bail jurisprudence that when the legislature does not escalate the conditions, we will not. In Satinder Antil, as a contradistinction to Siddharth, the categorization is something which the legislature has not permitted. So I think the 2 judges need to go back, revisit the 3 judges bench and adopt that view.
Point well taken. We are totally out of time. It was a very, very informative 2-part series on this issue of keeping people in jail post filing of charge sheet and its impact on the economy of India. We all are in work because businessmen dare to invest in this country. He takes a risk. I remember recording an episode with Justice M.M. Kumar long ago, wherein he said that it takes a big heart to commit 10,000 crores, even if by taking loan from a bank. You have to sleep with that debt every night. You have to commit money to the plant, and you take that risk on your own shoulders. It's not an easy thing. I would like to thank Advocate Tanveer Ahmed Mir, Senior Advocate Pramod Dubey, Senior Advocate Vikas Pava, Advocate Abhimanyu Bhandari, Nitesh Rana, Advocate Nitesh Rana, all wonderful inputs. I'm sure viewers would love these 2-part shows. This came in succession to our 4-part series on the defects in the Prevention of Money Laundering Act. It's kind of a succession to those episodes. Thank you so much for joining us. Thank you so much.
Thank you, Tarun.
Thank you for having us over.
Thank you, Tarun.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.